quorum present. The first order of business is approval of the last meeting's minutes. Representative Myers, would you like to move approval of the minutes for March 27th, 2025?
I move the minutes from March 27th, 2025.
Any discussion to the minutes? Hearing none, all those in favor signify by saying aye. Aye. Opposed? The motion prevails and the minutes for March 27th, 2025 are approved. Members, a scheduling order was issued to both parties on March 27th. Per the scheduling order, Representative Harry Niska, the petitioner, submitted a brief on Friday, April 4th. David Zoll, attorneys for Representative Tabke, submitted a brief on Tuesday, April 8th. Both briefs and the materials for today's hearing are posted on the committee webpage. Today we'll be hearing the oral presentations for the election contest of 54A. And before we'll begin, I'll go over the structure for today's hearing. We will operate this hearing the same way we do for regular committee meetings, so conversation will go through the chair. Everyone should have the election contest rules in their packets that were adopted on March 27th. Per the rules, the petitioner has the burden of proving by clear and convincing evidence that the respondent's election return should not be accepted or that the respondent is ineligible to be a House member. As we announced at the hearing on March 27th, the committee will only be considering what is in the court record that has been provided to the committee. The petitioner will be given up to 10 minutes uninterrupted to provide the committee with an initial presentation, followed by up to 10 minutes and uninterrupted from the respondent. And again, that is up to those lengths of time. And then we will be giving you a 3-minute warning so that you just know you can kind of keep track of time that way as well. And then we will move to questions for the petitioner. Republicans and Democrats will each have up to 5 minutes for questions to the petitioner, followed by questions to the respondent. And we'll be giving a 1-minute warning too in that part of the presentation, just so we can keep track of time for everybody. After the presentations and questions from members, the committee will move to discussion. And I said a lot there. Are there any questions from any of the members? All right, seeing none. And then do we have any questions from either Representative Niska or Mr. Zoll about the procedure today? Okay, seeing heads nodding that there are none. And so Representative Niska, please come to the testifiers table. As I said before, we'll hold up a sign when there's 3 minutes left too, so that you are able to kind of keep track of how much time is left. And we'll give you a minute to just tell us when you're ready to go and we'll start the timer.
Certainly, thank you, Madam Chair, ready to go.
All right, you may proceed.
Thank you, Madam Chair and members of the Ethics Committee. First of all, I want to make clear, very clear, because this committee is the Ethics Committee, that there is no impropriety towards, on the part of Representative Brad Tabke that is alleged or really under consideration in this matter. This matter is purely about the House's constitutional role to be the final judge of the returns and eligibility of its members, and it's important that we're clear that this is purely about a very narrow legal issue about what to do in with frankly undisputed facts, not just clear and convincing facts, but undisputed facts that 20 at least voters in Shakopee were disenfranchised because someone in the election process threw away their ballots. And the narrow legal question that we have to decide in our constitutional role as the judge of the returns of the elections is what to do about that in a situation in which people who should have been able to vote were not allowed to vote. Whether, as the district court did here, we tell those voters that in order for your vote to count, you must come into court and testify about how your vote counts, or else your vote might not count, or whether we, and as a result, put into the hands of those voters potentially the ability to decide the election through their testimony, or whether we recognize that that is an inconclusive result in a situation where, as here, we have 20 or possibly 21 disenfranchised voters and a margin of between the two candidates that's smaller than that. We think that the answer under Minnesota law, under controlling Minnesota law, and under the correct rule is that that voter testimony cannot be used reliably, and those voters cannot be put to the task of revealing who they voted for or losing the power of their vote. And I think that the language from an 1895 Minnesota Supreme Court decision, the reasoning in that 1895 Minnesota Supreme Court decision, which is consistent with many cases from a number of places across the country, is really instructive. And that case was called Pennington versus Hare. And there the Supreme Court said, in that case, the record presents the simple question, can votes not cast because of an error of judgment on the part of election officers be counted as if cast and returned? We are clearly of the opinion that they cannot be. Where, as in this case, the supposed ballots were never in existence, and we must rely upon the subsequent declaration of the electors as to how they intended to and would have marked and cast their ballots if they had voted, it would be an uncertain and dangerous experiment to attempt the task of ascertaining and giving effect to their intentions as ballots actually cast and returned. Uncertain because it would be simply a matter of speculation, dangerous because it would give to such electors the power of determining the result of the election in a close contest. All that would be necessary for them to do in such a case to decide the election would be to declare that they intended to vote for a particular candidate. It would enable them to sell the office to the candidate offering the highest price for it because they would not be called upon for their declaration until a contest arose after the actual ballots had been counted and the precise effect of their statement known. They could swear falsely as to their past intentions without fear of punishment, for how would it be possible to disprove their statements as their intention with reference to the supposed act if perchance they had acted? Now, no one is alleging, no one has attempted to prove that anyone's vote was bought. The issue is, what is the legal precedent that we're setting, and what are the incentives that get set up if we say, maybe in this election it was 20 ballots, next election, if it's 100 voters in a decision in a race decided by 15 votes, how are we going to decide those elections? Are we going to put it onto a voter who has a right to a secret ballot to either say you have to testify or your right to vote is in jeopardy? And what is that going to result in down the road? There have been other cases where voters who weren't eligible to vote have had their testimony considered. There's a Minnesota Supreme Court case around that. That raises different considerations. We're not asking someone with a right to vote to choose between giving up their right to vote and not voting. We're talking about the testimony of a voter, of someone who was not an eligible voter. And we're not creating the same incentive structure of giving them the potential ability to sway the election. So we should continue to follow the legal precedent, the legal rule that Pennington is setting out. Just like in that case, the voters didn't get to vote. Here we know that the voters' votes were thrown away and not counted. And for the same reason, we shouldn't ask them to testify. They shouldn't have been asked to testify perhaps in the first place, but we shouldn't be relying on their testimony to decide the election. And what that leaves us with is an inconclusive election, an election in which we don't know who the winner is, and every voter who has an opportunity to vote should be allowed to vote. Those 20 voters should not have been disenfranchised. They should have the opportunity to vote in a new election, and we submit that that is the proper remedy in this case. Thank you.
Thank you. Next, we'll hear from Mr. Zoll, so please come on up to the testifiers table. We'll give you a minute to get settled here. All right, you may begin your presentation.
Thank you, Madam Chair and committee members. You're further away than I'm used to judges being when I give oral arguments. I'm David Zoll of Lockridge Grindle-Now, and I'm here today on behalf of Representative Brad Tabke. Representative Tabke won the election. That was confirmed in the manual recount of the ballots. It was confirmed through Scott County's exhaustive investigation following the election, and it was confirmed in the two-day trial. And the particular thing that was determined in that trial is that the failure to count 20 ballots did not affect the outcome of the election. Brad Tabke is the duly elected representative for House District 54A. Petitioner's request is unprecedented. Petitioner asks the House to use the authority under Article 4, Section 6 to judge the election returns and qualifications of its own members in order to remove Representative Tabke from office, even though the district court found that Representative Tabke won the election, the failure to count those 20 ballots did not affect the outcome and dismissed the contest. The legislature has this authority, but it has never used it to reverse the court's conclusions and remove a seated member from the House. Why does the petitioner ask the House to take this extraordinary step? As Representative Niska acknowledged, it has nothing to do with the conduct of Representative Tabke. There's no allegation that Representative Tabke had done anything wrong. And it's not because of the shifts in the vote totals that are mentioned at the beginning of petitioner's brief. That's typical in the reporting and canvassing period of elections. It's because petitioner does not believe that the court or the Minnesota House of Representatives should rely on the voters' sworn testimony under oath and under the penalty of perjury about how and for whom they cast their ballots. That's the very heart of this issue. Petitioner asserted that 20 voters were disenfranchised. People who should have been allowed to vote were not allowed to vote. That's partially correct. These were 20 individuals who are eligible voters. They are eligible voters in Precinct 10 in Shakopee, and they were allowed to vote. They were allowed to vote, but there was an intervening event between them casting their ballots, placing them into the absentee ballot return envelopes, and then the counting of those ballots that caused them to be lost and discarded before being counted. But I want to be clear, these individuals had ballots in their hands. They filled those ballots out. They marked them, they cast their ballots, they voted in this election. And that's a key distinguishing factor from the Pennington case, where the voters in that matter were never allowed to vote. They were eligible, but the election judges on election day, for whatever reason, denied them the right. They never had a ballot in their hands and they never marked it. And the court expressed concern about hearing testimony from individuals about what they might have done in the past. The testimony from the 12 voters in this matter wasn't about what they might have done. It was about what they did, how they voted, how they marked their ballots. And also, to be clear, these individuals weren't told, you need to testify in order to have your votes counted in this election. I want to be clear, and the district court's opinion makes this point clear as well. It wasn't that these votes were counted. At the end of the day, at the end of the election contest, they didn't add 6 votes to the totals for Representative Tabke and add 6 votes to the totals for contestant Aaron Paul. Instead, the court concluded, based on that testimony from those 12 individual voters, that it was impossible for the outcome of that election to have been affected by the loss of those 20 ballots. All right? 20, 21, the math doesn't make a difference, and I'll explain why. There was a 14-vote margin. We had 6 voters testify that they voted for Tabke, 6 testify that they voted for Aaron Paul. At the end of that, there remained a 14-vote margin, and there's 8 or possibly 9 ballots that we don't have any evidence about how they were cast. But even if you assume that every single one of those was cast for Aaron Paul, he can't make up that 14-vote margin. And that is the basis for the district court's decision in this matter, based on all the evidence and all the testimony that the court heard, for concluding that the failure to count those ballots did not affect the outcome of the election. You don't have to take my word for it. You can review the trial transcript. You can review Judge Prezell's order. It recounts the exhaustive investigation performed by Scott County Elections Manager Julie Hansen in order to identify who were those specific 20 voters whose ballots were discarded. It includes the testimony of election judges Kay Gamble and Rocky Swearingen, who each confirmed the key pieces of Ms. Hansen's investigation. There is certainty And to quote from Judge Prezell's order in paragraph 107, there's no doubt, based on reason or common sense, that the 20 identified voters are in fact those for Shakopee Precinct 10 whose ballots were lost and not counted. We know who the 20 voters are, and 12 of them chose to testify about how they cast their ballots. They testified voluntarily, each and every one of them. They chose to testify in this matter. Their testimony was credible, and Judge Prezell described them as frank and sincere in providing their testimony. There is nothing in the record to suggest that their testimony is not completely trustworthy. And I don't want to go down too far in the rabbit hole of the analysis that the Supreme Court has made in various cases about voter testimony, but I think it's important to note this distinguishing factor. Petitioner Representative Niska commented about a distinction between allowing testimony from ineligible voters, those who were given ballots and allowed to vote, and in an election contest, the court concluded they shouldn't have been allowed to vote. What do we do? And on the other hand, what happened here? You had eligible voters who were given ballots, allowed to vote, and their ballots were lost, all right? In the case of an ineligible voter, if they testify honestly and truthfully about who they cast their ballot for, the end result is a -1 vote change for their candidate of choice. If they have an ineligible vote that's coming out of the pile and they say that they voted for candidate A because that's who they supported, that's a strike against their candidate. In this circumstance, the motivations are a 180-degree difference of that. There's the motivation for these voters to testify honestly and truthfully, A, because they're under oath and under penalty of perjury. And we trust we trust witness testimony in the courts. But more importantly, if we're just looking at motivation, a vote for a testimony that they voted for the candidate of their choosing, candidate A, results in an increased likelihood that the candidate that they support is the one who is going to win the election contest. The motivations suggest that the testimony from these voters is truthful and honest and trustworthy. And again, this is a public trial. Anybody was welcome to attend, and they could hear firsthand, see firsthand this voter testimony and assess the credibility for themselves. And that's precisely what Judge Prezell did in presiding over this matter. She does what every judge and every jury in Minnesota does in a trial, which is to assess the credibility of witnesses. And again, she found the voters to be sincere, candid, and honest in their testimony. It's important here to circle back to the rules for this committee's consideration of the election contest. Rule 7 of the rules, which was recounted by Chair Moeller, establishes a standard of proof that must be met to unseat a member. And the petitioner must prove by clear and convincing evidence that the election returns should not be accepted. The evidence here falls exactly the opposite way. The evidence proves clearly and convincingly that Representative Tabke won the election and is the duly elected representative for House District 54A. And Rule 8 provides that the committee may set aside the court's findings of fact in an election contest only if it finds that the court's findings were clearly erroneous, giving deference to the court's opportunity to evaluate witness credibility. The trial court's findings cannot be deemed clearly erroneous. You need only review the trial transcript and the court's order and the evidence for yourself to see that it is grounded in fact and grounded in reliable testimony. And for these reasons, Representative Tabke respectfully requests that the committee conclude that he is the duly elected representative for House District 54A and recommend that the House take no further action with respect to this contest. Thank you.
Thank you, Mr. Zoll. Next, we'll move to questions by the Republican members of the committee for Representative Niska. And as a reminder, we'll have them go through the chair just because that's the process we're used to. And we'll give a 1-minute warning to everybody just so they know when it's time to wrap up. And I'm not sure if you prefer, Chair Davids, do you want to start with one of you and then move to the other, or do you want to go back and forth? I'm not sure how you'd like to proceed.
Thank you, Madam Chair. I have no questions for the petitioner, but Representative Myers might.
Okay, Representative Myers.
Thank you, Madam Chair. Thank you, Representative Niska. You know, had a chance to look through most of these documents, and there is, you know, concern, there is pause for me in some of this stuff. You know, voting is a right. It's something that should be protected, but it should also be something that's private. And I think, you know, we heard here, you know, some conflicting testimony, but, you know, I've got a concern of that precedent that is potentially going to be set, not only for this, but for the future. And I'm interested from your perspective, what that precedent can do now, but what potentially it can do in the future, along with what the legislature should do about it.
Representative Niska.
Multiple questions, sorry, Madam Chair.
Thank you, Madam Chair. Thank you, Representative Myers, for that question. Yeah, that is the primary concern, I think, driving the rule in Pennington versus Hare, and I think the rule that we should be concerned about here, which is that although the voters here were not expressly told by the court that they would lose their right to vote if they didn't testify, that was very clearly understood by every voter who was told by one of the lawyers in the case, hey, you're on this list that Scott County has said are the people whose ballots have been thrown away. They all knew at that point the margin of the election. And if we set this precedent going forward and allow for in a future case, and perhaps it's a case where the margin is narrower or the number of missing voters is larger, that we are creating an incentive structure where voters will be placed in a position, and I believe the 20 voters here were all placed in that position of having to face, do I come to court and testify, give up my right to a secret ballot by testifying in court? And the judge did make admirable, I think, effort to try to protect the privacy of those people. But as Mr. Zoll said, anyone could have come into court and watched that testimony. So those voters were being asked to either come into court, testify in open court about who they voted for, a very secret thing that can create different problems for different people depending on their own personal circumstances, or lose potentially the effect of their vote. And that is very concerning. It should be concerning to all of us who care about both the disenfranchisement of voters and the loss of the right to a secret ballot for voters.
Representative Myers.
Thank you, Madam Chair. You know, from my experience and Representative Cleaborn, I'm going to probably think she probably has the same experience, but I won't speak for her yet. You know, we go out and talk to a lot of people as we're out door knocking, have those conversations. And, you know, you get to that point in an election season where you start knocking on those doors and people say, oh, I already voted. I think people have learned real quick, you don't ask who you vote for. Putting those people. We don't want to do that, and I just can see this going down an avenue that puts people, pressure on people that can cause, you know, harm to, you know, our election process. And we're all looking for, you know, safe, secure, and accessible elections. You know, so I would just think long and hard about that piece.
All right, I didn't hear a question in there, so any further discussion from either Representative Myers or Chair Davids? And for people who are watching, Representative Bennett is an alternate, and so that's why she is here but not participating. I am not trying to ignore you, Representative Bennett. All right, I don't see any more questions on your side, and I'll move on to ours, and we'll start the timer over again. Representative Cleaborn, do you have any questions?
I wasn't sure I was going to ask a question, so I don't have this as well formulated as I would like, which is always kind of a dangerous thing. But I'm thinking about the process. And in the process, we have the court who heard these individuals, did not force any individual to testify, and those who chose not to testify, those votes, as you stated, were given to the candidate with the least amount of votes so that the outcome of the case could be determined, the outcome of the election could be determined, and that we can see that mathematically Representative Tabke had the most votes at the end of that testimony. So my question to you is, when a voter does cast a ballot like this, and they do wish to testify, is it our right as legislators to take that right away from a voter?
Representative Niska.
Thank you, Madam Chair, and thank you, Representative Cleavorn. I don't see it as a question of right. It's a question of what is legally admissible evidence in a contest such as this. And I think that the Pennington case says it's not legally admissible evidence because it is creating a situation in which the only way that that voter has a vote in that election is to come in and testify, is to give up their right to a secret ballot. So it's not that, that person would not be allowed to say, you know what, I was told I was one of the voters and I voted for Brad Tabke. They could, write a letter to the editor. They could, say that publicly if they wished to do so. But in a legal proceeding, we don't necessarily say, and every person who thinks they have something relevant to say has the right to say it and have it be relied on in the legal proceeding. And so the question is really about what is reliable legal evidence that goes to the question of who received the most votes. And I think that's where Pennington makes a sensible rule that it would not be reliable evidence in a court proceeding.
Representative Cleavorn.
Well, I will disagree with your premise that Pennington is the case that we should be relying on, as it had to deal with ballots that were never cast. These ballots were, in fact, put into the ballot box, as we heard Mr. Zoll say. But also in Pennington, if I were to take the assumption that you have that Pennington is a reliable case, in Pennington it says if a ballot is marked, right, then the ballot must be given the effect, no matter how crude the mark might be, right? So even in Pennington, it says that the voter has the right to have their ballot cast if they are eligible, right? And in Pennington, they weren't eligible, where in this case, they were eligible. Which leads me to the next question I would have for you. When the contestant put forward their case, they stipulated with the court and with Representative Tabke that they would go and ask these voters to come. That was an agreement. They agreed that these were the 20 voters. They agreed that these...
There's 1 minute left. Sorry to interrupt.
Oh, sorry. They were agreed that they would go through this process. And contestant Paul also worked on the process to bring them in. So how is it now that we should be throwing out that process, throwing out those voters, and saying we should not hear their voices?
Representative Niska.
Thank you, Madam Chair and Representative Cleavorn. I think you have the record a little bit mistaken in terms of there certainly was not an agreement. One of the contested factual issues in the case was about which 20 voters, whether the list of voters was the identified 20 voters. And to be clear, the court found that as a factual matter, that list was correct. And we're not disputing that factual question. There were pretrial discussions that were not on the transcript in which it was discussed about whether voters would be called to testify, whether some of those voters would be called to testify. And I think, I was not part of those conversations.
And I'll just say 5 minutes is up, and we are confining our remarks to what is actually on the record. So we will stop there, and then we'll move up to Mr. Zoll. Please come forward.
Thank you.
I'll give you a minute to get settled here. And we'll begin with questions on this side again. It looks like Representative Myers, you're ready.
Thank you, Madam Chair. Thank you, Mr. Zoll. Couple questions. One, does the legislature have the ultimate authority to make the decision to seat their members?
Mr. Zoll.
Madam Chair and Representative Myers, that is what is provided in Article 4, Section 6 of the Minnesota Constitution, that the legislature is the judge of the election returns and qualifications of its members, though I do note that the committee is bound by the rules established in the evidentiary requirements burden of proof that were established for election contest in the rules.
Representative Myers.
Thank you, Madam Chair. Mr. Zoll, also, is it correct that voters in certain instances have the opportunity to change their votes through the election cycle?
Mr. Zoll.
Yes, I won't go into the precise details of what that is, but there are limited opportunities in which an individual who's cast an absentee ballot can have that ballot essentially spoiled prior to it having been accepted by the election officials.
Representative Myers.
Thank you, Madam Chair. Moving to some of the information was in here, the testimony, I have a tough time understanding how we are having our locally elected leaders certify elections when there's more missing votes than what the winning total was. From your perspective, do you believe that process needs to be reviewed or changed through the legislature?
Mr. Zoll.
Madam Chair and Representative Myers, I don't. What is certified by the local election officials is the results of the ballots that are counted, and that is the certification that is made by the canvassing board. If there are questions, such as arose in this matter, there is a method already established in Minnesota law, which was used in this case, an election contest to resolve whatever lingering questions there may be regarding the results of the election. We have a process in Minnesota for addressing this.
Representative Myers.
Thank you, Madam Chair. What I hate to see, though, is we're putting our locally elected officials in a really tough spot, and this may be one of those cases. One final question. Shakopee had a long-standing city clerk that oversaw the election. I believe that individual worked there maybe 20 years, and right after the election, that person quit. Do you know why that was?
That is, I don't believe that is in the record. Would you be able to point us to where that information is in the record, please?
So I can say that,
We can just, let's pause the timer there too, so I don't want to cut into your time there.
no, what I can say is that person was referenced in there, and I'm trying to better understand where that person was or was not in this, this process, given that they're a big part of the election.
So I will let Mr. Zoll answer the question, but only to the extent there's information in the record.
Thank you, Chair Mueller and Representative Myers. Your question of why the individual is no longer at the city of Shakopee is a question to which I do not know the answer. That the answer to that question is not in the record. Within the record, there is testimony regarding that individual's role in the election process, and that is described in the court's order. But I would, anything beyond that, I have no information, nor is there information in the record.
Representative Myers.
No further questions. Thank you.
All right. Chair Davids.
Thank you, Chair Mueller. I find this to be quite troubling. I do thank Mr. Zoll and Representative Niska for stating on the record that this is not really about Representative Tabke and him doing anything, and you both said that, and I'm glad that's on the record because he's really put in a spot here. But to say with total certainty that the courts did the right thing, I take pause. You got 20 missing ballots, and people came in with testimony, but
And Chair Davids, I'm just giving you the 1 minute warning. Sorry.
1 minute warning.
Yeah, okay.
I had about a 10-minute speech.
Sorry. Keep going.
So I just find it troubling that we're accepting ballots, we're accepting testimony on ballots that don't exist. They're not there. So to say with all certainty that everything's okay I do have a problem with that. I'll just leave it at that.
All right, and we can move on to member discussions from this side. Representative Cleburne? Okay. So I have a couple of questions, Mr. Zoll. I did note that the court found that the argument that was raised by petitioner in his reply brief, which to me seems to be the same argument that's being presented to us today, was waived. Is that correct?
Chair Mueller, your recollection of the court's finding is correct. And in my view, the court's finding itself is correct. There was no objection made by contestant to any voter testimony. There was no attempt to cross-examine or discredit any of the voter testimony. And if there were any doubt about the admissibility of this testimony after what was raised in the argument in the reply brief, the contestant had the opportunity to raise that question with the Minnesota Supreme Court. He could have asked the court what it thought of Pennington, what it thought of subsequent decisions by the Minnesota Supreme Court that did consider voter testimony, and contestant did not take advantage of the opportunity to raise that question with the Minnesota Supreme Court, who could have answered its view on the admissibility of that evidence.
And Mr. Zoll, my take on this as well is that the Pennington case that's relied on now was raised for the first time in the reply brief as well. Is that correct?
Chair Mueller, that is correct.
And I just wanted to ask you a couple of questions about the district court's credibility determinations. It's true, isn't it true that the court found the Scott County Elections Administrator Hansen to be a credible witness?
Chair Mueller, that is correct.
And the court also found that the county identified the 20 voters whose votes were not counted. Is that correct?
Chair Mueller, that is correct.
The county found that those voters were identified in Exhibit 10, an exhibit that was in fact introduced by Mr. Paul. Is that correct?
Chair Mueller, that is correct.
And the court found that Hansen's testimony and conclusions were credible. Is that correct?
Chair Mueller, that is correct.
The court also found that 12 of the 20 identified voters testified, including 6 of whom Mr. Paul called as a witness. Is that correct?
Chair Mueller, that is correct.
And the court found that the 12 voters appeared frank and sincere. Is that correct?
Chair Mueller, that is correct.
And Mr. Paul introduced Exhibit 10. That's the absentee ballot request and signature envelopes for voters 1 through 20. Is that correct?
Chair Mueller, that is correct.
And Mr. Paul's attorney did not object to Mr. Tabke's voter election documents that were introduced as Exhibits 304 to 320. Is that correct?
Chair Mueller, that is correct.
And the court rejected Mr. Paul's claim that Scott County hasn't linked the 20 uncounted ballots to the 20 voters identified in Exhibit 9, saying, quote, "The credible evidence proves otherwise." Is that correct?
Chair Mueller, that is correct.
I have no further questions. Thank you. All right, you may leave the table now. And we will move on to member discussions. Representative Myers.
Thank you, Madam Chair. First time sitting on this committee, knowing it's, again, ethics, but we're not here to address an ethics complaint, but election contest. I think we've seen some things from the court record. There's a lot of unanswered questions. And again, this gives me pause in the fact that we do have 20 missing ballots. We are requiring our locally elected officials to certify an election and put these people in a place, especially when there's more ballots missing than the winning margin. We've seen a long, almost 20-year employee of the city of Shakopee, that's the clerk down there that oversees all the elections, that all of a sudden right after the election is no longer employed there. That gives me some reason for pause, but it also, then you look at some of the court proceedings and you look at the precedent that we are putting on voters, and I talked about it briefly before, but protecting their right to vote, their privacy to vote. We talk a lot down here about safe, secure, accessible elections. And I think these decisions like this can have a big impact, not only here, but in the future. And I think, you know, I don't sit on the elections committee. I haven't seen the elections bill. I'm sure hoping that there's some things that can be addressed here, because there are some missing pieces here. And I hope and I think everybody's going to have a little bit of pause after some of this.
Further discussion? I'll make a few comments then as well. We do have Chapter 209 that covers election contests and explicitly says the judge shall decide the contest, issue appropriate orders, and make written findings of fact and conclusions of law. I know while ultimately it is our decision, that process was followed in this case, and the court made a number of findings of fact. And I think that, I know that the burden of proof is on the petitioner. Our rules state that the burden is to prove that the findings of fact are clearly erroneous. There has been no attempt made to establish that those findings are clearly erroneous. I went through a number of those findings of fact with Attorney Zoll. And again, no effort was made to show that they were clearly erroneous, and instead relying on cases that were cited in a reply brief for the first time after petitioner's attorney had actually called these witnesses that were voters, introduced a number of the relevant exhibits in this case, and didn't make any effort really to cross-examine any of these voters. And so, a process was followed in this case. We were given findings of fact by the district court judge. Obviously, what happened below was troubling. No one can dispute that. But given what our role is here and the rules that we've set out here, I don't believe the petitioner has met his burden of proof. Chair Davids.
Madam Chair, when it's the appropriate time, I'd like to make a motion.
I think everybody's said their piece, so please go ahead.
I would move to recommend that the House reject the election returns and declare a vacancy for House District 54A. And I suppose I should ask for a roll call.
All right, Chair Davids has moved to recommend that the House reject the election returns and declare a vacancy for House District 54A. The clerk will take the roll.
Chair Mueller.
No.
Chair Mueller, no. Chair Davids. Chair Davids, aye. Representative Cleavorn.
No.
Representative Cleavorn, no. Representative Myers. Representative Myers, aye. There being 2 ayes and 2 nays.
There being 2 ayes and 2 nays, the motion does not prevail. Representative Cleavorn.
Thank you, Madam Chair. And I would like to make a motion that we move to recommend that the House take no further action regarding the election results for House District 54A.
All right, Chair Cleavorn moves to recommend that the House take no further action regarding the election returns for House District 54A, and I'll request a roll call.
Madam,
Oh.
can we discuss?
Oh, sure, we can discuss that, sorry.
I'm leaning towards actually voting for that because of the previous vote here. We're not taking any action, so if we're not taking any action, I would say we probably should support this motion so we take no further action. Because I want to put this thing to rest, and my motion did not prevail. We had a vote on it and it failed. So I'm leaning towards voting the affirmative on the Claiborne motion. Thank you, Madam Chair.
Any further discussion? All right, seeing none, the clerk will take the roll.
Chair Mueller.
Aye.
Chair Mueller, aye. Chair Davids. Chair Davids, aye. Representative Cleavorn.
Aye.
Representative Cleavorn, aye. Representative Myers. Representative Myers, aye. 4 ayes, 0 nays.
There being 4 ayes and 0 nays, the motion to recommend that the House take no further action regarding the election returns for House District 54A has been approved. And with that, I think the work before this committee is done. I want to thank all the staff for preparing, getting these binders ready for all of us, and for the presentations today by both Representative Niska and Attorney Zoll. And with that, we are adjourned.